Tell us when we can get on. Don't forget to click on whatever that one thing that needs to be clicked on.
These are nice mics. Yeah.
All right. You guys about ready?
Ready? Let's do it.
I've got everything on mute right now, so give me a sec.
Are we on video?
4, 3.
Hi, welcome to Courtside Live. I'm Robert Tyler, Bob Tyler sometime. That's going to be a good one because there's, every year in California, there are so many new laws coming out. Contact us with your questions about asset protection strategies, your estate planning. This is the subject matter of what we're talking about today. You can visit our website for more information at www.tylerbursch.com. And you can send an email to us at info@tylerbursch.com. And please subscribe to our YouTube channel. We're going to be providing more and more information. This is kind of a new thing we've started with COVID-19 hitting. There's a lot of great opportunity for us now to set up and get information dispersed on new laws, et cetera, through through the YouTube channel, but also follow us on Facebook and Instagram and Parler. Parler's a new, really a conservative-oriented Instagram that supposedly doesn't censor. So we'll see. We'll see if they censor us. All right. Well, let's jump. First, we'll just give you a quick glimpse of our practice areas. We have, I think we have about 10 attorneys at the firm right now. And we focus in different areas. Today we're talking about, as we said, asset protection and estate planning, an area that Todd's doing a lot of work. But we do a lot of work for churches and nonprofit organizations, serving as general counsel to them, estate planning, employment law, real estate law, business law, with trademarks, when a lot of times when companies come in and they're launching their corporations and entities, new businesses. And we also have a nonprofit organization called Advocates for Faith and Freedom, where we have lawyers who are dedicated to pro bono work and the First Amendment protecting civil liberties. And so, that's generally the scope of what we do. And let's jump right into covering our assets. Okay.
It's interesting, too. You're talking about these different practice areas, and so many of them are touched by asset protection. I mean, your real estate and your business, all of those type of things. I get people all the time that'll ask questions about, hey, I'm looking at getting a revocable living trust. I think this would be a good way. I've heard this is a good way to protect my assets from creditors. And, we have to let them know that, where an asset, where a trust can be a really good way to avoid paying more taxes than you need to pay. And for preventing going through probate, saving money that way, it really does nothing for protecting your assets from creditors. So
Right.
We're going to be talking more about, protection from creditor claims, basically, then, right?
Yeah. So I think one way to answer the question is, what is asset protection? A lot of times, frankly, this is an area of law that I think most lawyers, frankly, now we're a small firm, frankly, 10 lawyers. It's not very large. And, in some of the largest law firms, they have folks who kind of specialize in asset protection. There's some boutique organizations. But most law firms really never really do that crossover between estate planning and asset protection and really understand the distinction between the two. I would say, I shouldn't say they don't understand, but there's some confusion. And so let's talk about what asset protection generally is not. And so it's not generally estate planning. Estate planning is beneficial because we can have some great tax avoidance strategies, and that's protecting your assets when you die. So there's some asset protection there. But as you said, a living trust doesn't protect your assets against your creditors. A living trust does nothing to that extent. An irrevocable trust is a different story, and irrevocable trusts are a strategy that can be used, and we incorporate those at times. And so we'll jump into this. Let's talk about asset protection is really about creditor deterrence. So, generally speaking, people who are interested in asset protection are going to be people who have assets and people who are engaged in business. And when I say assets, I'm talking about people who have investment assets, generally above and beyond their home. Generally, they've got rental property, maybe something outside of a 401k plan. 401k plans and qualified plans generally have protection from creditors to a large degree. There's a lot more to that, but we're talking about people who have assets that are outside of 401k, outside of their own single family home. And they might have a business, they might have rental real estate, other investment real estate, and maybe investments in other companies. So that's generally what we're talking about. And then what happens in those situations is what happens if there's a car accident and you're driving down the road, it's at night, and it's just an accident. I mean, I just heard a horrible story the other day of someone who pulled out, was elderly, and unfortunately someone passed away as a result of this accident, and it was a negligent act, and that person's looking at the potential for manslaughter charges now, even though it was just an accident. Things like that do happen, and they can really devastate your estate. And we're not here to talk about to try to create injustice. That's not really what we want to talk about. But there are strategies to try to favor settlements, to try to encourage people to settle, which is the second point on our slide here. Is asset protection, generally what we are talking about is trying to create a situation where if someone decides they're going to bring a lawsuit against you, you're going to make it difficult for them. So you're not just saying handing your assets over on a silver platter, no strategy is 100% fail safe that we engage in. So I think that's an important thing to say. I'd ask you, Todd, what's the first thing you think about when someone comes into you and says, I've got a claim, I was wronged, something happened to me, and I want to bring a lawsuit? What do you think?
Well, the first question always is going to be, does the person that you're looking at going after for taking care of this thing, do they have anything? Is there anything to collect at the end of the day? Because lawsuits, as you know, are not cheap. The last thing you want to do is throw a significant amount of money behind a lawsuit to win that judgment and to find out that it's uncollectible. Right.
More often than not, we've seen that so many times where people want to bring a lawsuit. I've had circumstances in litigation where you're in litigation, you tell somebody you really should settle this case, and then the closer you get, the more difficult the case is to win. It's never a perfect case, and then you start looking at their assets, and that's the first thing you're going to want to do. You're going to want to take a look at their assets. So let's jump into that. Sometimes the idea behind asset protection, sometimes it does bar collection, but our real goal is, again, creditor deterrence. Let's look at how assets are located. I see here that in our analysis, we want to figure out where first are we going to find where are we going to find assets? So if I'm a plaintiff's lawyer, I'm looking at certain places. So first place you go.
Go on and look at the public record, see what real property they own.
Mm-hmm.
Yeah.
Do you ever go on that website, Corporation Wiki?
I do, and Manta as well has a similar type of a thing where you can find out, that Joe Smith is a president of this corporation and this corporation. You start being able to find out, what entities that they're involved in.
Yeah.
You can find quite a bit of stuff on there.
Had we thought about it, this actually would have been a great thing right now to say, okay, let's pick someone we know.
Yeah.
Someone who'd be willing. But you actually go into, like, on Corporation Wiki, which you do, and what I've done often with clients sitting in my office, I say, okay, I've done this for two different ways. One, I've had clients in my office who are considering asset protection strategies. They're thinking about, how do I protect myself? I say, well, let's take a look and see what the corporate records show you're involved in. And you type in their name into the Corporation Wiki, and boom, it pops up and it shows all of these connections and all these corporations that they have some relationship to. And then the other thing that I have seen happen as well is that when I've sat back with clients who are plaintiffs, and they've been wondering, do they have any assets? What I'll do sometimes there is jump right into it, and we'll look it up and we'll see, gosh, look at all these different companies they're involved in. It actually helps to uncover questions of relationships between people, right? I actually did that not long ago, and we found out that a former business partner who absconded with a bunch of money opened another company with their CPA. And that's how we found out about this potential issue. So public records, and through the Secretary of State. Todd, you do a lot of corporate formations. What information does the Secretary of State typically retain?
So for Secretary of State, for any corporation at least, they're going to be listing who all the directors are of that corporation, who the officers are, who their agent for service of process is, and they'll be showing where the corporate address is. I mean, so you'll see situations a lot of times where the guy owns his own corporation. He's the sole member of that corporation, so there's one director who's filling all the roles as officers, and they might be using a home address for process, for instance. So if you're trying to track down the guy, figures out a way to maybe hide some of this stuff, but neglects to change it on the Secretary of State, where the guy's property is. So if you then look that up and find out that property's owned by some LLC, you got a pretty good idea then, where it actually ends.
And LLCs, generally the corporate records reflect, or the Secretary of State reflects, who the managers are and who the agents for service of process is, and also members. And so we have strategies that we'll talk about a little bit later about how do you avoid, anonymity is, to me, the key to asset protection.
Agree.
Anonymity, if you can keep your name out of the public record and prevent people from knowing what you own, that is a wonderful deterrent to prevent people from seeing, oh, here's somebody with deep pockets.
Right.
And we've got private investigators. We'll talk about that.
Right.
Post-judgment procedures are available. We'll go through that here in just a minute. Let's go to the next slide. So public records. We've talked about that. In addition to the Secretary of State, there's a county recorder's office where you have title for real estate. There's the DMV for boats and cars. And then also there's the UCC filings that you can get from the Secretary of State. UCC is the Uniform Commercial Code, where a lot of times you take a loan out and the bank wants a UCC filing against a business or assets, and it'll often identify all of the assets that are part of that are owned by that business. And so that's an area. if you have a deed of trust and you have a recording, someone owes you money and you record it with a deed of trust and you're the beneficiary of that when it gets paid off, that shows up. Any other thoughts?
Those are the primary ones,
Yeah.
I think. Yeah, I think we hit most of them.
Yeah, even judgments. Actually, that's on our list here too.
Well,
Judgments that might be recorded with the county recorder's office. There you have it. Someone says, "Oh, you've got a judgment against Joe Blow for $50,000, and you owe me $50,000. So I'm just going to go and attach your judgment, and I'm gonna
and
pursue
that's
that."
searchable as well through the recorder's office, because typically what happens is when you get a judgment, you're going to record an abstract of judgment in
Right.
the county. That's going to show up as well, then
Mhm.
showing that you've got this judgment.
Yeah. We actually, boy, we spent a lot of time already on the Secretary of State. Is there anything here I think that we haven't talked about? Actually, here, being licensed by a state agency or designated as the RMO, Responsible Managing Officer, or RME, Responsible Managing Employee of a company where there's a license. So, for example, a contractor has to have a contractor's license. And other licenses that exist, a broker for a real estate company, for example, they will require that a responsible managing officer be designated. And so if you're that officer, you show up. You show up in the public record.
Yeah.
Same as an employee. I actually had a horrible case one time where my client was a contractor, and he was an architect, licensed contractor, and he was designated as the responsible managing employee. He didn't own the company at all. It was a development and construction firm. They had hundreds of employees. They got behind in payroll taxes to the tune of over $1 million. And who did the IRS come after? They came after the responsible managing employee, who was designated as, it was his contractor's license that was being used. And he was subject to the liability, and it was a horrible thing for he and his family. And
that's
it just
personal
devastated
liability in that case too, right?
Personal liability, because those are considered trust funds by the
Right.
IRS. All right, so private investigators. This is always interesting, how private investigators go about searching. You always wonder, in the past years, they were able to find bank records. And you thought, wait a minute, how in the world do they find bank records? And my experience was that what would happen is they would often, one way of doing it would be they would call up a bank and represent themselves to be the name of the individual. And they would have that individual's social security number, and they'd say, "What's my bank balance?" And the bank would give them that information. That was in the years past.
Mhm.
But now, there's other ways. Have you heard of other ways that PIs?
Yeah,
private
I
investigators have
mean,
obtained
they'll
info.
do a lot of stuff. I mean, going through trash cans, going through a lot of times people won't take care of getting rid of their documents properly, and they'll find that type of thing. It's really amazing what they can find. I mean, we had a recent case here where we were dissolving a corporation that had existed since the 30s. Shareholders had disappeared, and the original shareholders, who purchased their shares in 1930, these guys were able to find who their descendants were through the line to find out who the rightful heirs of these shares might be, 90 years later.
Wow.
They can do a lot of stuff. They can find a lot.
And also, what I've actually seen and heard, I want to ask a private investigator, how did you get that bank information? And they said, I can't tell you.
Mm-hmm.
Can't tell you how I got it. And and I've heard that there are people in government positions who sell information. I wish it wasn't true, but there are people who have access to top secret kind of clearances, probably, who are accessing bank records. And so that happens. And so something to think about. And as you said, rummaging through trash. That was one private investigator. He said, what we do? We'll go rummage through trash from a business or a person's residence, and we'll find bank statements that are put in the trash. And sometimes people will tear up their envelopes, for example. They just tear them up and they throw them in. Well, look, all they have to do is piece the envelope back together and they see, oh, it says Bank of America.
Right.
So then they go to Bank of America in that hometown because, of course, they're going to bank near their house probably or near the business. And so they find information in incredible ways. So use shredders. That's an important point.
Mm-hmm.
Use shredders. And as I said, sometimes they'll search banks near your business just to try to determine whether you have an account and how much you have in there.
Right.
All right. So post-judgment, there's also, if someone gets a judgment against you, you actually can be hauled into a judgment debtor exam, right?
Right. And they have the right to ask you pretty much about the location of anything you have, any type of assets, even what you have in your wallet at the time when you walk in the door. I mean, so it's really broad what they can get at those.
And you're put under oath. Typically, there's a court reporter who will be there transcribing everything while you're testifying, and they're asking you, what bank accounts do you have? And part of that typically, and I've done this, is I've demanded that the creditors show up, the debtor show up to court, and they bring all their documents that show their financials.
Mm-hmm.
And I want to see. So I get their account numbers, I get their company info, I get everything they own. I can learn all of that information. And sometimes and then what happens if the debtor's not participating and voluntarily giving us the information, we can take them right into court because we'll go,
right.
Because typically this happen outside the court,
Mm-hmm.
right in the hallway. And sometimes we'll actually do it in front of the judge, and then the judge orders the person to give that information. And so these are ways to go about getting that information that, we as, lawyers sometimes will go in and we'll attach once we got a judgment. And once we find out where their information is, we can go in, we can attach bank accounts. And that means that we put a freeze on their account and the judge orders that the money be taken out and paid to the creditor. Mm-hmm. Real estate, we get liens on them. We can foreclose against the real estate, cars, assets, coins. I had one time where, we had a box of Rolex watches that were turned over, so anyways, a lot of ways to get a lot of stuff. So, okay, we've talked about, those are the big horrors, right?
Right.
Defensive strategies. Why don't you lead us off on this?
Well, there are quite a few. I think that one of the first ones, is the ability to form a corporation. A lot of people will come to us and say, hey, I've heard that, I can use a corporation to protect my personal assets from liability from something the corporation does. Mm-hmm. But we should talk more, obviously, about how that works the other way.
Yeah, we have some slides.
Yeah.
LLCs as well.
Yeah, LLCs, exactly. There are different agreements that you can make. You mentioned earlier the idea of irrevocable trusts. Mm-hmm. There's transmutation agreements where a married couple can say, this piece of property is now sole property of the other spouse, for instance.
How about out-of-state assets? We kind of skipped over that. Out-of-state assets, out-of-country assets. As a lawyer, a lot of times what you might do is when you have a private investigator and they go out and they do a search, well, it's more expensive to do a search across the entire country than it is to do a search just in in one state typically. Right. So a lot of times, someone who holds assets in another state, that's kind of puts it at a greater distance, especially when it's out of country. I've have people who have bank accounts in Canada and et cetera. So
Cayman Islands and yeah. The other one that is a big one is qualified plans, ERISA qualified plans, right. Retirement plans, even from bankruptcy courts. Those assets are exempt basically to at least $1 million, and to the extent that they're necessary for that person's support.
So we talked about that a little bit earlier. You actually do bankruptcies as well. Mm-hmm. So, you represent people in bankruptcy and those who are not in creditors on the other side. Right. But so from a bankruptcy perspective, if someone has a qualified plan and they file for bankruptcy, just explain that just a little bit more. You said $1 million. $1 million of what?
Right. So basically what happens in a bankruptcy is the bankruptcy trustee, their job is to try to find assets to take from that debtor and give those assets to the unsecured creditors. So what we end up happening is we have to go through and we have to find ways to exempt these assets. So, for instance, your home would have an amount of an exemption depending upon whether you're single or married or over 65.
It's
That's going to range from around $100,000 to around $175,000 of equity that we can exempt.
that means that your house is that 175,000 or whatever the actual number is. I'm surprised it's up that high, but I guess it's that high now. So up to 175, I think, if you're a married couple. I thought it was 120.
Over 65 years of age or blind. It goes up to that amount.
Okay, so let's say it's up to that number, $175,000. That means you file bankruptcy and you qualify for that exemption. You're up to $175,000 of your property is exempt from being exempt from being sold off and used to pay creditors.
Right, correct. So, like, let's say that you've got a house and you've got a $500,000 house and you've got $100,000 of equity in it, and we have an exemption that can be used to protect $100,000 of equity. The trustee doesn't have any way of going after anything. It's all exempt or immune from the trustee being able to come after it. Now, with retirement plans, that amount is huge. So like I said, the minimum amount that we can exempt on an ERISA qualified plan is $1 million. You can go up even higher than that if you can show that more is necessary for your continued support.
How about homestead agreements or homestead declarations? We haven't actually. That's not even in our presentation here. But there's an exemption if you file that in advance, right?
Yeah, and that's going to be dependent upon whether you're selling the house voluntarily or whether a creditor is taking it. It's the main thing with the homestead exemption. It's similar though to the bankruptcy exemption. I mean, it's a dollar amount that you're allowed to protect from creditors.
So let's say you don't qualify for bankruptcy because we're talking about people who have assets, have businesses, and they're doing asset protection. One of the ways they can protect some of their assets is they file homestead, and that protects. I don't remember the current numbers, but I think it's somewhere if you're married up to $150,000. I think.
And there's an automatic homestead exemption from creditors being able to come after it. The homestead exemption would actually protect, let's say you sold that property and now you've got it sitting in a bank account waiting to buy a new property. That homestead exemption would protect that transition period.
Okay.
But we've got an automatic one. Like, you're right. I mean, your home has an automatic protection in it.
So another aspect we haven't talked about is insurance. Now we'll talk about insurance a little bit later. Obviously, insurance is almost the first line of defense in most instances. Let's talk about corporations. So you're a corporate guy. Corporate shield, good protection, bad protection. What does it do?
I think it's a very good protection for the stockholders from corporate liabilities. So let's say that you own a corporation and you've got your own personal assets and the corporation has its assets. And let's say that your corporation builds something that turns out to be defective in some way and somebody's injured. And that person then comes after the corporation and tries to sue the corporation. They can do that. They can go after the corporate assets. But to get to your personal assets, they have to do what's called pierce the corporate veil. The way that you help prevent that from happening, and piercing the corporate veil is just a real simple way of saying, we're going to disregard the corporation and we're going to go after your personal assets as if you owned everything. So what we're trying to do always in corporate law is really try to make sure that people understand how important it is to follow all the corporate formalities. I can get a little anal on that sometimes, but making sure that you're documenting corporate decisions, that you're not commingling assets. You need to treat it as if that corporation is a separate entity, almost like it's a separate person that has to make its own decisions separate and apart from you.
And the basic minimum, let's talk about what are the basic minimums for corporate formalities. We're talking about minutes, annual minutes, right?
Yep. Need to have annual minutes for an annual meeting of the shareholders and the directors. There needs to be an annual statement of information that we talked about a little earlier that gets filed with the Secretary of State that tells the public who your directors and your officers are. And there's an annual tax that gets paid. that's the bare bones minimum stuff that needs to be done.
So talking about that, often we have people, so often, people form a corporation and they don't maintain minutes.
Mhm.
They don't have annual minutes that are maintained, and they don't have their annual meetings.
Right.
And often it's a mom and pop corporation, and they're trying to have this corporate shield. So a lot of times that's one area. And so sometimes they come into us and they haven't done minutes for 10, 20 years. We've seen that. I've seen that.
Right.
You know, and you go back and you say, okay, well, you know, it's tough to recreate minutes when they didn't have a meeting. So you have to, you know, follow those corporate formalities. And that's one of the things that we offer at Tyler and Bursch is for, you know, a small fee on an annualized basis. We do those minutes.
Mhm.
We have our paralegals in-house who will call you and find out, you know, what's happened in your corporation, draft the minutes on your behalf, address the formalities that need to be, maybe address annual compensation of the corporate officers, identify who the directors and the officers are on an annualized basis. And, you know, I've actually seen in the nonprofit world, and this is interesting, in the nonprofit world, we've had minutes that were not properly managed. And we had a board that from like 10 years earlier who came in because now this nonprofit owned a bunch of real estate that was worth a lot of money. And so that board from 10 years earlier came in and said, hey, wait a minute, we're still the rightful board. This new board has no authority. They end up in a lawsuit, and the old board prevails because they didn't maintain their corporate minutes to identify the transfer of directors and owners. So, you know, in the nonprofit world, that was really important, and there were still a lot of assets at stake in that case. So I guess minutes. Another aspect of this is commingling. You commingle your assets. What happens?
Okay, then it's basically what ends up happening is they just treat it as if you and the corporation are the same thing.
The creditors treat the courts,
exactly.
And the creditors say, hey, you commingled your assets.
Yeah, you treated this like it was your own personal piggy bank. Well, now your personal assets are going to be personal piggy bank for the corporation. Kind of goes both ways in that. So, you know, I've seen this lots of times, unfortunately, where people are, you know, paying kids' tuition directly from a corporation.
Yeah.
Or paying a car payment for a personal car, that type of thing, without any formalities to show that this is a corporate vehicle. It's being used for corporate purposes. Those are the things they're looking for. And if they can show that you've been doing that, it's not going to end well.
Yeah. And same for, I had a client one time who had a problem with, this was, you know, during the recession of the 2008, 2009 era. And they got behind in taxes with the Employment Development Department. And so, you know, one of the things that they did is they came back and they said, wait a minute here. They start doing this investigation to see where they were paying their money and what was being paid. And they end up finding that this, you know, the client of ours, without our help, actually started another entity. They started another company and launched another company, put it under, you know, another family member's name. Well, that's considered a fraudulent transfer, right? What happens when you have a fraudulent transfer?
They basically, well, beyond there being other penalties involved, I mean, they'll pull that right back in, like as if that transfer, the court will pull that right back like it never happened.
And the creditors will sue you for fraudulent transfer of assets.
And you'll be paying basically the cost for them to get that property back to where it should have been in the first place. You know, that's the one thing I do have people come to me once in a while and say, hey, I was involved in this lawsuit and it didn't go well, and I'm wondering, can I transfer this stuff into this corporation right now? And you know, as far as fraudulent transfers, that's going to be right up there with it. I mean, they're going to be, you cannot be. I think this is where what you were talking about earlier, where a lot of attorneys really don't like to talk much about asset protection. I think that they've kind of gotten confused in their mind, and they're not looking at the fact that there's a major difference between planning for what might happen. Look, if you're planning for what might have happened in 2006 and 2008 happened, good for you. If you wait around until 2008 when the bank is trying to come after you for delinquent debts and they've got a judgment or they're in hot pursuit, and you start transferring assets, that's a fraudulent transfer.
Yeah. So the moral of the story is when you want to do asset protection, or when the time to do asset protection is before you know of any creditors that you have that that are going to come after you, or more importantly, I think the right way to say it is before you get yourself into any trouble. That's when you need to be doing asset protection. You need to be doing asset protection when things are good.
Right.
And when things are good, unfortunately, a lot of people, it's happened to me multiple occasions where I've done asset protection for some people. They got a little frustrated because they felt like, well, gosh, this is a little bit too complicated. You have me in these different entities and everything's great. And then get frustrated at me. And then 2009 hits. And then what happens?
Yeah.
They come back and they're thanking me saying, "Oh my gosh, I thought you didn't know what you were talking about."
Right.
I literally had a client tell me that one time. He says, "Bob, I just didn't think you knew what you were talking about. I thought you were just, you know." And then he comes back, he says, "Thank you." I'm like, "Why?" Because the government was coming after him. He was involved in a medical business, and that medical business, with the social, what is it called? It's the payments that come from the government for Medi-Cal and Medicare. That's what it is. And they're pretty aggressive. And so when it happened and they started coming after him wrongfully and he ended up winning that situation, he had asset protection. And he was thankful that he had that asset protection ahead of time, because they would not have been able to go after some of those assets. So key to this is plan, do asset protection ahead of time. That's what a corporation is. You form a corporation to protect your personal assets. You form a limited liability company to protect your assets. You do that in advance of the liabilities. You do that in advance of the business starting. That is asset protection. There's nothing illegal about it unless you are doing it to defraud creditors that is a judgment that you have against you.
Yeah.
Let's jump stock real quickly. Stock is not protected from creditors of the stockholder. So that is, that's talking not about the creditors of the corporation. That's talking about the creditors of the shareholder.
Right.
There's something called inside creditors, outside creditors. I like to just put it this way: business creditors of the corporation. If you have a corporation and you're a shareholder of that corporation, you're protected. But we're talking about personal creditors. It's that situation where you're driving on the weekend to the beach and you get in an accident and someone sues you. That's a personal creditor.
Right.
And so corporate stock or a corporation isn't going to protect your ownership of that stock. And what can happen in California? What happens in California if a personal creditor seeks to attach stock?
Well, they would just be able to attach the stock, and as the stock is just an asset, a personal asset of each stockholder, they're able just to attach that, get those shares, and now they own the company.
Right. Exactly.
Yeah.
And that is one of the things where I think a lot of people don't understand that. I have seen this too many times where individuals in a car accident who have $300,000-$400,000 of liability insurance, and someone dies. Well, you know what? $300,000-$400,000 when you're negligent in a car accident and someone died on the other side, and it's not a business debt. It's you were on the weekend going to the beach. Well, that's a personal judgment that's going to be obtained against you, and you own a very successful company, and that creditor, that family, the survivors are going to be able to come and attach your stock, take your company, right? And that's what happens in California, and so it's difficult, and in most states that's permissible with a corporation. That's why sometimes a corporation is not the best way to hold ownership, to hold stock. There are other ways. You can sometimes hold stock in a irrevocable trust or some other things like that if the corporation is the best way to go. But LLCs are an alternative, and we'll talk about that next.
Yeah, there we go.
All right. So limited liability companies. This is really important, and I'll jump on this one because I've done a lot of work in this area. It's really good. It's really good protection for members who have personal liabilities. So same way, Todd, why don't you give the formalities, what's required in an LLC first, and then we'll talk about how it works as an asset protection device.
Well, so I mean, a lot of people I think understand corporations pretty well. I mean, there's articles of incorporation to form it. There's stock issued to the people that own those shares of stock are shareholders or stockholders, and that company is run by directors and officers. Limited liability companies function in a lot the same ways. They use different words. So we've got articles of organization. We have rather than having bylaws in a corporation, we've got articles of organization. We've got rather than shareholders, we've got members. We have managers rather than directors, that type of thing. But they don't require the same level of formalities overall. Once that's done,
do you have to have annual meetings?
No, you don't.
Do you have to have minutes?
You don't.
How about commingling? Is that permitted?
No. I was going to say there are some interesting kind of sidelights to that, but no. It's difficult for an LLC really to get in trouble with not following the corporate formalities. I still, in my own way of thinking, I still like them to do things. I still think it's a good idea to kind of follow some formalities for making decisions and that type of thing, just for showing the decision making was following some type of a plan.
Yeah.
But
in litigation, we call the type of lawsuit that you might bring against someone who has an LLC is you're going to say, or even a corporation, if they're commingling their assets, if they're not really treating it as a separate entity, you call it the alter ego doctrine.
Right.
You say this is your alter ego, and you file a cause of action based on the alter ego doctrine. And so the idea is to don't make it your alter ego, like you're saying. Treat it separate. Treat it independently. And how about for tax purposes? There's different ways to deal with that.
Yeah, no, a corporation, can be taxed either on the corporate level as a C corp, or it can be taxed after the distribution as an S corp. Limited liability companies can be taxed either as basically like a corporation or more like a partnership. So we've got different options on that, and those type of questions kind of get outside the scope of what I like to even advise people on. I like to work in conjunction with the client's tax prepared tax advisor and make sure that we're setting it up in the best way possible for them. But that's the basics are that it's set up where you could be taxed as a partnership.
Okay.
Unlike a corporation.
And you can have a single member LLC, or you can have multi-members in the LLC.
Yep.
You can have a manager managed LLC where you have a manager who's not even an owner, who's designated as the manager, or you could have one owner designated as the manager and the rest of the members are not managers. So numerous different ways to be able to structure that.
Yeah.
So let's talk about this, the charging orders, and this is important. So a charging order is the way that a creditor comes and they get an attachment. So this, again, let's go back to you're driving down to the beach and creditor comes, or excuse me, you're in an accident. You're negligent. You're not in the scope of your business. So it is a personal liability of yours, and you have a limited liability company. And depending on where your limited liability company is formed, which state it's in, is going to depend on how it's treated. Now, a charging order is the process by which someone comes along and gets in litigation. They get a judgment against you personally. They find that you own membership interest in a limited liability company. They find that you have a stock in a corporation. So they look at that corporation, they say, okay, I'm going to own that stock, and they attach it. But when it comes to the limited liability company, they don't really have that same ability. With the stock in a corp, they can pretty much go and do like a foreclosure, just like on a residential or real property, a foreclosure of that real property. It's not the same terms, but that's how it works. With an LLC, it's not a foreclosure. They don't get the right to own your membership interest generally in an LLC formed in the right states. Okay. Now, what happens is they get a charging order in these states that we've we actually will identify in the next slide. So stick with us. So what happens is they get it's like a garnishment of wages or a garnishment of distributions that are paid out of the LLC to the members. And that's what a charging order is. If the charging order is considered to be the exclusive remedy and the only remedy that creditors have, then they don't have the right to get a foreclosure on your membership interest. And then some states like California have kind of a hybrid. In California, the charging order is not the exclusive remedy, but it's a situation where the creditor can actually almost become a quasi-member until they are fully paid, and then the membership interest goes back to the original member. But when you have a charging order, here's the key. Here's what's pretty cool about this, is that in certain states, a charging order, if it is the exclusive remedy, means that the creditor gets a attachment, so to speak, a charging order against all distributions, all profits that are to be paid to that particular member. And then what ends up happening is, let's say that the LLC, the manager is still in charge, the manager is still in control of distributions and how much gets paid out. Then what happens is the manager says, we're not going to pay any more distributions because we're going to reinvest. We're going to buy real estate. We're going to reinvest in capital for equipment or whatever it might be necessary. Then what happens is, generally speaking, that creditor who has that charging order that's been applied, they stand in the shoes of the member. So they get the benefit of distributions if they're paid, but they also get the liability of what we call phantom income, because when distributions are not paid out, it's retained income, and that becomes a taxable event effectively to the members. And if the creditor is standing in the shoes of the member and the company says, well, you would have got $100,000 this year, but we're keeping it, and we're going to go buy either real estate or we're going to reinvest it in other things, tax has to be paid on that $100,000. And because it's an LLC, the member is responsible and liable to pay that tax on an annual basis.
So the creditor is going to end up having to pay the tax in that scenario.
Exactly. Yeah. So they pay what I call phantom income for tax purposes, for taxes that they never got. And then where, in other states, they do allow foreclosure on a member's interest. Let's talk about those states here where the charging order is the exclusive remedy. In other words, no foreclosure allowed, but only charging orders are permitted. So here you have them: Alaska, Arizona, Alabama, Connecticut, Delaware, New Jersey, Texas, Indiana, Kansas, Louisiana, Maine, Michigan, Mississippi, New Hampshire, Florida. Both of those states, by the way, the exclusive remedy of a charging order is only applicable if it's a multi-member LLC. And then North Dakota, North Carolina, Ohio, Tennessee, Virginia, and Wyoming. So those are states where the exclusive remedy. So what I'll do a lot of times is, if I'm meeting with a client and they want to form an LLC because they have assets, and if they have assets in one of those states, I'll say, okay, well, why don't we take your real estate that you own in Texas and let's form an entity in Texas, and Texas will be this state, and it's a perfect place. You're doing business there, and then we can put your California assets in that Texas LLC. So things like that we can do.
Right.
And then, I had one client one time who had an LLC, and I believe that was in New Hampshire, and a creditor in court tried to attach the membership interest of that entity in New Hampshire. And what we were able to do was go to court and say, Your Honor, the New Hampshire law applies, because the law of the state of original jurisdiction is the state where it's incorporated. Even though they could get a judgment in California, in order to foreclose on someone's membership interest that's from New Hampshire, they've got to go to New Hampshire. And New Hampshire doesn't allow anything other than a charging order as the exclusive remedy. So we were able to litigate. We won that.
Right.
It was
Well, it's a huge deterrent, obviously, to any plaintiff's lawyer as well. If they're
Right.
thinking, hey, I'm a California attorney, this is a California plaintiff, California defendant, a business that's really doing a lot of its business here in California, but we're going to have to go to New Hampshire to fight this thing.
Yeah.
Cost of litigation just went up.
Right. Right. So, and then they don't want to go to New Hampshire because they know that it's, the exclusive remedy is a charging order.
Right.
And so when you talk to the creditor, you say, look, you can get a charging order, but, any income, it's not going to be distributed, and the manager is going to retain control. And so, why don't we just find a way to settle this case? And that works.
Mm-hmm.
And we've done that. We've seen it. It definitely helps. And you want a choice of law provision in your operating agreement as well that says, when you're doing business that your choice of law is this particular state. You can put that in contracts with third parties. You put it in your operating agreement. And so important. What about foreign entities? So if we have a Texas entity that owns California real estate, do we need to do anything in California?
Yeah, California is still going to require you to register to do business here in California. And they broadened so much the definition of what constitutes doing business that pretty much if you're doing anything here anymore, it's probably a good idea. They've determined that it's like even if this is where the directors live, or this is where the directors have phone conferences from here.
Mm-hmm.
It's gotten very broad. I don't know whether that's going to be defensible by the state, but that's the position they're taking.
So you'll have an extra $800 a year,
Yeah.
and you have to file the annual statement of information as
Yep.
well. I'm just going to touch on family limited partnerships. Not my favorite. What about you? Is that?
No.
Yeah. So,
No.
but it is a strategy that can be used. Family limited partnerships typically, there's a way where sometimes you'll have it's basically a limited liability partnership where you have the general partner is someone who has a very small interest who controls the assets that are in the family limited partnership. And sometimes it's used to distribute assets, but really what I have found is that I think a better way to accomplish this is to actually use an LLC instead of a family limited partnership.
Definitely less cumbersome.
Yeah. Let's jump to the next strategy: segregating assets, separating risk. If someone wants to be extremely conservative, what will they do with real estate? If they own 3 properties, what would the conservative person do?
Well, the conservative person would have each of those entities or each of those properties in a separate LLC. They'd be single asset LLCs.
What causes you to decide, for somebody whether they should have multiple LLCs for each real estate parcel or investment?
Really, I mean, my main consultation with them is trying to find out what equity's in those properties. Because if all of these properties are encumbered up to basically the value of the property, put them all in one LLC. It doesn't make sense to you to be paying additional costs every year for that. But if you start getting equity in each of these properties, I think it's a good idea to separate them.
Yeah.
Maybe one of them has increased in value and you only need 2 and you've got 3 assets. But definitely a good idea to separate them as much as feasible.
And sometimes you have to look at how much equity and how much profit's coming out of the property versus, the annual $800 a year.
Right.
Does it just make sense to pay that additional $800? And well, frankly, it's like an added insurance policy that sometimes is worth it, sometimes it's not.
Right.
And you also have to consider the risk of the asset. That's one of these I often look at is, okay, here you have a self-storage facility that you own that you have, very limited equity in it, but it's going to grow in value. And over here, you own a toxic waste dump. You don't want to put anything into this toxic waste dump because there's so much risk associated with that particular asset. So you keep them in separate entities. Equipment owned by LLCs. That's one of the ways that I've worked with clients, and they basically set a LLC up just to own equipment, to protect valuable equipment. And there's some tax benefits to that. Have you done that? Have you worked with that much?
Yeah, I mean the company vehicles in some cases, will be owned by one LLC. The other one will then lease those vehicles back, and they're able to kind of segregate the risk that way too.
Yeah. And then, just different business operations. A lot of times you have people come in and they say, well, I'm running a construction business here. And, I have a cooking studio over here with, someone else runs this. My daughter runs the cooking studio. I run the construction business, and, my wife has a different business, and we're all under one corporation. You're like, wait a minute. There's lots of liability in the construction business.
Right.
Keep that separate.
Right.
All right. So here's a strategy that, that can be used, and we kind of use these flow charts a lot of times. At the top, you have customers, vendors, employers, third parties, creditors, tenants. Those are typically those who might create a liability to somebody who owns a business, right? So let's say XYZ business LP, it's a limited partnership, for example, here is doing business, and the threats come from typically those individuals that are listed at the top. And so we try to have insurance in the middle to create a hedge of protection. And then we have the limited partnership. Sometimes maybe it's an LLC, which is really what I prefer rather than a limited partnership, but it's an example. And let's say that here you have the husband and wife who owns 51% of the business. And one of the ways that I have companies where families say, you know what, I've got enough assets of my own. I want to create an entity because I'm already pushing the estate tax threshold, or I might owe estate tax when I die. Let's get let's have my children own an interest right off the bat, but they're minors. So we create a children's trust, and you have the children own 49%. The husband and wife's living trust owns 51%. And then you have a general partner. And who's that general partner? It's an LLC. And that LLC controls the XYZ business. And so there's this strategy to provide this protection so that if you have third-party creditors that come against the children because they get older, well, there's a spendthrift clause that protects against creditors. The husband and wife living trust, well, they own 51%, but there's a general partner who actually controls, who makes all of the decisions. If it might be a manager. And so that's what we have here, where it identifies these different strategies where, this LLC could own 1%, and you can have the manager of that LLC be a trusted friend, a brother, sibling, someone who you trust, who's going to make all the right decisions so that you're not in control of it. So if you have personal liabilities that come along, this is just kind of one asset protection strategy. You'll see down below, you have real estate investments, LLCs, and in a similar way, just, turn it in reverse. Here you can have, it can be owned, the LLC, the members of the LLC could be the husband and wife holding 51%, 48% held by a children's trust, or maybe it's not, maybe it's other third parties, and then 1% held by another LLC. And the idea here is that, let's say that some creditor comes along and the husband drives and he's negligent, there's an accident, and insurance is just not enough to protect. And then he can say, well, I'm not making the decisions whether or not distributions are coming out, and so the assets are there protected. This next proposed business plan, very complicated. Frankly, we don't have enough time to jump into it. But there are some various ways that we really have the ability to make sure that we provide anonymity. And, in California, if you own assets outside the state, the idea is that we will often use maybe you can use a child, maybe a daughter who's taken the name of her husband and has a different name, right?
Right.
And it's not your last name. And they are the manager of an LLC. And you trust that daughter who's going to do everything right. But you, as the parents, own the LLC. The daughter is just designated as the manager. And you, as the parents, have the ability to remove that daughter at any point in time as a manager if you want to. But you don't, because that daughter, when they register that Texas LLC, for example, in California as a foreign corporation, the parents' names are not on the foreign designation. Only the manager's name is on there. So you don't show up in public record.
Right.
Right?
Right.
Anonymity. I mean, what do you think about anonymity? Why is that so important?
Well, I agree. I mean, it goes back to the whole thing about the plaintiff's lawyers trying to track down assets. I mean, yeah, this even goes over to where you just showed the hypothetical there with having the trust. The trust, I mean, most people just go, well, I want to form this trust, and my name's John and Jane Smith. Okay, it's the John and Jane Smith Trust.
Mm-hmm.
The real property is going to be owned by that, the residents, other things. There's nothing in the world that says you have to name your trust that.
Right.
You can name your trust the XYZ Trust.
Mm-hmm.
And then when they go searching to see what you own, your name doesn't show up anywhere.
Right.
So, yeah, big, anonymity is huge.
Yeah. Let's jump to insurance. Insurance protection. So big categories, physical assets, intangible assets, and future earnings. These are all categories where insurance can protect. We're kind of coming to a close, so hang with us here. Personal insurance coverage, automobile. Todd, what's the minimum amount of automobile insurance coverage someone with assets should maintain?
As much as they can maintain.
Yeah.
No,
So,
but really, I mean, it's like, I mean, I typically will tell people at a minimum $300,000
minimum,
but as much as you can afford. I mean, typically.
Yeah. And so here's what I will typically do is I'll tell people, I say, look, I've had those circumstances where my client had $300,000 and literally there was a major injury. That's not enough to cover a major injury. I mean, someone breaks their leg and it's going to have permanent damage to them. What is that worth? Is it worth $300,000? I tell people, I said, consider. You want to go, when you think about what happens, how much is it worth for you to have a broken leg and have permanent injury because of your broken leg? And someone's like, man, okay, you're going to pay me $300,000 or something. You're like, okay, well, $300,000 insurance might be enough. But really, you want to get as much as you can.
Mm-hmm.
Homeowners insurance, similar situation, right? You want good coverage, but a lot of times homeowners not so, you don't have such ability to say, well, I want a policy that's going to give me, $1 million, $5 million in coverage on homeowners. Rental property, boy.
Yeah. Seen plenty of cases where they haven't had that and that turned out not well at all.
Mold.
Yeah, mold. Definitely. It's been a huge issue.
Vacation property, boats, motorcycles, ATVs, vacant land. I've had a lot of people that have not had insurance coverage on vacant land. And that's risky. Yeah. Someone comes on your land and
gets injured.
Yeah. And here's the important thing, umbrella coverage. So like what I recommend all the time is they say, you need to get a $5 million umbrella policy if you can. And that $5 million is going to be above and beyond. You might have a $300,000 automobile policy, but you'll have this $5 million that steps in if the $300,000 is not enough for coverage. What are your thoughts on total liability?
No, I agree completely with that. It's one of those situations too, where it's like, I mean, if somebody's like walking down the street and you've got your homeowner's policy and your dog goes out and God forbid mauls you into somebody, that your typical homeowner's policy isn't going to cover those injuries, but the umbrella policy will. And in a lot of cases, the umbrella policy is going to follow you, wherever you are, rather than be attached to, this didn't occur at home. It's going to cover other occurrences. Huge,
very, very important. Business insurance. Okay, let's run down this list real briefly as well. There's a lot of different types of business insurance. And how about you? I mean, I found that a lot of times, someone comes in with a claim and they're like, oh, it's not covered. Oh, you didn't happen to buy that extra endorsement. Right. Commercial general liability, that's the thing that most people go with, and they say, okay, I got a business, I've got commercial general liability, or it's an investment property, and it's a commercial general liability typically. But you need commercial auto, right? If you have people who drive periodically for you in your business, who go somewhere, pick something up from the grocery store for whatever, go to the Office Depot to pick things up, and they get in a car accident on the job. Commercial auto is important, right? Business property, business income to protect your property inside, and even business income insurance. And that's kind of a tougher one, right?
Yeah, especially now.
Yeah.
People have been arguing about this a lot now with the whole COVID situation and whether it's covered under business income or business interruption. And it's interesting. So these are going to be policy by policy kind of decisions.
And a lot of the insurance companies, unfortunately, are really fighting
Mm-hmm.
that COVID, causes them to actually have to pay anything out, right?
Yeah. Well, the liability is going to be huge if it's determined that is covered.
Right. Professional liability, errors and omissions, huge,
Mm-hmm.
right? For those who can obtain that insurance. Here's one too: employment practices liability insurance. That's a must today. Sexual harassment, defamation, wrongful termination. That's a must. You just and that is a separate policy.
Right.
Cyber liability. Have you had any cases dealing with cyber liability?
I haven't.
I have, and big deals. Thankfully, the organization we had cyber liability, and right now, because of all the laws are changing with all the consumer privacy laws, if you have a website up and there's something wrong with your website, it doesn't have ADA protection, or ADA access, you can be sued. If somehow you have a situation where someone taps in and what do they call that?
Like hacks
into your system and somehow gets your information. Liability, right? They take that, and next thing you know, because of California's laws, there's like minimum liability requirements for that. Employee dishonesty, someone steals from you. Have you ever had any claim like that? I've actually. Have you?
Yeah. Yeah, I've had that. We're actually dealing with one now, currently, where there's a situation like that.
And did the insurance company said? Did they have insurance? I should ask.
They did not.
There you go.
No.
Okay, if you had insurance, could have been helpful.
Yeah.
Directors and officers policies, important, especially for nonprofits, but also for companies that you have directors and officers who may not actually be owners of the company. That's important. And then again, an umbrella policy for business.
Right.
And then other considerations, we talked about out-of-state assets, out-of-country assets. We've talked about all of this already. So let's jump to qualified plans, and we talked about this.
Actually hit that already.
Boy, we got a lot done here.
There you go.
Well, that concludes it. Actually, for every individual, it gets pretty unique, doesn't it?
Mm-hmm. Definitely, it's case by case basis every time, and not only is it a case by case basis, but I think that it changes through time with each client. So what might have been the plan now might need to be looked at again in a few years.
Yeah.
Just to make sure it's being kept up on, because those assets are going to shift in value. Kids are going to grow up. Things are going to change. So it needs to be looked at.
Yeah. And a lot of times people come in and they're very specific and they say, look, I just want a corporation. I just want you to do this for me. And a lot of times, we've had circumstances what we try to do, what I like doing is saying, let's look at the whole picture. Let's look at your estate plan. Let's look at your asset protection strategies that you're using, and let's take the whole picture.
Right.
And it's especially a good time when you're doing estate planning, because the client's coming in and they're giving you all that information already, right?
Right.
So you can make some good recommendations.
Yeah, definitely.
Well, if you have any questions, you are welcome to contact our office, and you can call us at 951-600-2733. That's our Riverside County office, our main office. We also have offices in Orange County. Again, thanks for joining us on protecting your assets. And next Courtside Live, we're going to be talking about new laws for 2021 and things that particularly businesses are going to be needing to know about and thinking about. Boy, last year there was a huge change in employment laws. We know that there are new changes already in employment law that we're going to be addressing, and so be looking for articles from us on our. We send out a newsletter, so you can join our newsletter and you can get those in addition to listening to us here. And that, to get our newsletter, you can go onto our website at www.tylerbursch.com, BURSCH.com. Send us an email at info@tylerbursch.com. And again, Please subscribe to this YouTube. We appreciate it. We appreciate you listening in. We hope that this has been a valuable asset for you, and welcome you to call us and then like us on Facebook, Parlor, and Instagram. And appreciate all of our clients so much. You know, we've been very blessed in what we are doing. And so keep coming. Thank you. God bless you.